very session, it's about claims management and dispute resolution in the construction sector. As we all know, these sessions are always recorded, and a recording is provided the following day. So tomorrow morning, you're going to have the recording sent to your email and of course circulated through our social media pages. I want to thank you one more time for, of course, coming in for this session. And I hope that it's going to be fruitful and an engaging learning environment for all of us. For the start, I would like to share just a short video here as we wait for the rest of the members to join us.
Through this video we will discuss the common causes of conflict that exist in the construction industry. Most construction projects end in disputes. This is why construction disputes take more time and the efforts of the project management team to resolve. If solutions such as negotiation do not work, then alternative dispute resolution methods will be available before litigation approach is sought. Construction projects involve many parties other than the main parties to the contract. The employer, consultants, main contractor, subcontractors and suppliers are the main parties involved in any construction project. It is therefore essential to manage all parties to the contract with appropriate project management solutions. Although the construction project is well planned, it can end in disputes and issues. So disagreements are common in construction projects. The most common causes of construction disputes: errors in submitting a claim, different site conditions, construction delay, errors in contract, delay in interest. Errors in submitting a claim. Claims are a common cause of construction disputes. There are many claim situations that arise in the construction process, including change claims, time extensions and other types of claims such as prolongation claims. These claims must be made in accordance with the contract. Poorly drafted claims without proper supporting documents can be grounds for disputes. Different site conditions. Bids are submitted based on current site conditions. This is why bidders are encouraged to visit the site before submitting their bids for evaluation. However, when construction begins, the condition of the site can vary due to soil condition, subsurface conditions, and unexpected structures and obstructions. These conditions can lead to conflicts. Construction delay. Most construction projects end later than planned. If the contractor does not perform his duties in accordance with the project program, this may cause delays in the construction project. This can lead to disputes and even liquidated damages being imposed on the contractor where applicable. Mistakes in the contract or mismanagement of contract. Documents including drawings are another cause of disputes. But with the right documentation and verification process, these mistakes are easy to avoid. The contract management process begins with a properly drafted contract document. If there are errors in the contract document, they can create grounds for disputes. Many claim cases are not a good sign of contract management. If the construction process does not comply with the contract drawings and specifications, this is a cause of disputes. The contractor must follow the standards and specifications stipulated in the construction contract prior to delivery. Defects and poor quality result in disputes between the parties. invoices. The employer delays the payment of the specified time. This situation can create disagreements between the parties and may even lead to a suspension of work. How to avoid construction disputes? By good project management.
Thank you very much for your attention on that very video. These are just but some of the major causes of construction dispute. I know as you execute various projects, you have faced some or many of these challenges. And today I don't want to take a lot of time because I know the speaker is he has a lot for us. And therefore, I would like just to open the session to three people. Get to know what would you want to learn from this what would you want to learn from this webinar, specifically on claims management and dispute resolution. So I'm going to open the floor to just three people, and then the speaker is going to take over from that point. So please, three people, and then Engineer Barasa is going to take over from that point. What are you anticipating to learn today? Let's get to hear. One, two, and then three. Therefore, I'm going to invite Engineer Barasa Ogeti so that he can take us through today's session, which is claims, dispute, and arbitration. Engineer, please, you may take it away. Thank you very much.
Okay, thank you. Thank you, James, for welcoming me, and thank you to all the people who've found time to make it here today. I'm happy to be with you for the third session, and I'm trusting that at the end of it, we'll all have gained something. I just want to take the first moment of this seminar to remember all those who lost their lives. For those of you in Kenya, you're aware that some people lost their lives in the ongoing protests. So just a moment to remember those who have lost their lives or their loved ones. Shall we begin? Today, being the third session, we're going to talk about claims, disputes, and arbitration. And I realized from the second session that I tried to pack a lot of information I tried to squeeze a lot of information into one seminar, and perhaps it wasn't as fruitful as we ought to have received it in the end. So for this seminar, I've kept it lean and simple, but I hope that still at the end of it all, you will have gained something of importance. So I'd just like to commence by proceeding with my presentation. As I've said, we are going to be speaking about claims, disputes, and arbitration. And I'm the same person who spoke to you last time. I still look the same. And this is what we're going to be talking about. The first session we're going to talk about is claims. So we're going to, first of all, define what a claim is. Then we'll look at the timeline of a claim in the context of FIDIC contracts. And as I said, I'll not try to squeeze in so much time. So we'll only limit ourselves to the FIDIC 1999 versions. And for those of you who are here from the beginning, you'll know the difference between 1999 and 2017. We'll look at why it's important to first give a notice. Then we'll look at the basic elements of a claim, which I've called the essentials of a claim. And from there, we'll move to the second part, disputes and arbitration. What is a dispute and what is the role of an engineer in the disputes? And we'll have a quick look at dispute boards. And finally, the dispute resolution procedure in the context of FIDIC claims. So, let us start. Claims. Now, a claim in the context of FIDIC contracts is an assertion of a party's right under the terms of a contract or under law. This means that one party is making a demand or a request within the provisions of the contract or otherwise under the governing law of the contract. And if you remember from the first seminar that we had, we spoke about governing law and why it's important, that beside only the contract that you've signed, the governing law plays a huge part in the resolution or in the interpretation of the contract or in the resolution of disputes that arise as a result of the contract. So sometimes on site, I hear people, especially you engineers, say that the contractor has submitted the claim. But essentially what you mean is the contractor has submitted an application for payment in IPC. That's something that we need to distinguish. Applications for IPC are not called the claim, are not called a claim, especially under the purview of FIDIC contracts. Under FIDIC contracts, claim is something entirely different. It is a demand or request for something considered one's due. Essentially, a claim is a request from one party, usually the contractor, for something which he or she considers is due to him or her under the terms of the contract. This is not to say that only contractors can make claims. Even employers under the contract can make a claim because there's two parties to the contract and FIDIC contracts are fair and balanced. So the contractor is in a position to make a claim, and so is the employer as well under the FIDIC contracts. Having defined what a claim is, and having said that we're restricting ourselves to FIDIC 1999, under FIDIC 1999, FIDIC subclause 20.1 is the subclause which deals with contractors' claims. Under FIDIC 1999 versions, FIDIC subclause 2.5 is what deals with employers' claims. Now, in the latter versions of FIDIC 2017, all claims have been lumped together in subclause 20.2, and they're called in clause 20, and it's called employers and contractors' claims. So both parties can make a claim under subclause 20.2 in FIDIC 2017 using the same clause. And that's a minor distinction. We won't get too much into the 2017 versions, but it's important if any of your projects are using a FIDIC 2017, you note that distinction. Now, in FIDIC 1999 version, subclause 20.1 states the following. If the contractor, as you can see on your screen, considers himself to be entitled to any extension of time for completion and or additional payment under any clause of these conditions or others in connection with the contract, the contractor shall give notice to the engineer describing the event giving rise to the claim, and the notice should not be given any later than 28 days after the contractor became aware or should have become aware of the event or the circumstance. Now, there's a lot to unpack in that clause, but there are a few things that I just wanted to highlight. The first one is entitlement or the consideration for entitlement. Then the second thing is under any clause of these conditions. So for a claim to happen, it has to be under any clause of these conditions, which is the contract, and there has to be an entitlement by the contractor. The third thing is the contractor must give notice, and we shall get into that as why that is important quite soon. And the notice must describe the event or circumstance giving rise to the claim. And finally, the notice should not be later than 28 days after the contractor became aware. So if, as a contractor, you've encountered something within your contract and you consider this an entitlement to additional payment or to an extension of the time which you have been told you must complete the project, then you must give notice within 28 days of that event arising, or rather of you having become aware. Now, this is always a point of contention, and the video which James played just a few minutes ago spoke about causes of disputes. Now, one big cause of dispute usually in contracts is, or in FIDIC contracts, is usually that phrase should have become aware. The question which is challenged to any contractor's notice was, you should have become aware of this more than 28 days ago. You surely cannot be aware of that situation right now. And basically that happens a lot in contracts. Now, subclause 2.5 deals with the employer's claims. Last time we saw how many clauses are in FIDIC. If you can remember, we have 20 clauses in FIDIC, or 21 in the 2017 versions. So these numbers are the numbers of the clauses, and FIDIC 2.5 deals with employer's claims. And what does it say? It says if the employer considers himself entitled to any payment under any clause of these conditions or otherwise in connection with the contract, and to the extension of the defects period, the employer or the engineer. Now, this is where you as engineers come in, if for those of you who will be practicing as consultants and not practicing with the contractors, you as the engineer, or for those of you in government bodies, you as the employer, or other bodies which use FIDIC contracts, not necessarily government bodies, you as the employer shall give notice and particulars to the contractor. Notice the difference between these two. For 20.1, the employer is only meant to give notice describing the event giving rise to the claim. Okay? And in 2.5, the employer or engineer gives notice and particulars. Now, you'll notice the difference that the contractor is required to submit particulars much later, but the employer should give the notice and the particulars. We are not told if there's a time span in between, but generally it's at the same time. So that is a very small distinction which you as employers, when you're managing your contract, you should be aware of. Whenever you give a notice to extend the defects notification period or otherwise in connection to the contract, maybe to levy delay damages and so on and so forth, you must give notice and particulars whenever you consider yourself. Now here, look, again, there's a difference here. There's no time limit. There's no 28 days for you. I see Renee has raised a hand. We'll have a coffee break in the next few slides. So just note down your question and I'll come back to that. Thank you, Renee. If you have any questions, just in the interest of smooth sailing, just save them. We'll have a coffee break for all questions and then we'll proceed with the slides, then have another coffee break and so on. So notice the difference here. The employer is not required to give a notice within a particular time bar. So that 28 days is what in the industry is called a time bar. There's a time within which you must give notice. And actually, if you have a FIDIC contract in front of you, subclause 20.1 proceeds to say, if the contractor does not give notice, then the following provisions do not apply. Meaning, if you do not give notice within 28 days, you lose or risk losing your entitlement to whatever claim you felt entitled to under any clause of these conditions. Now, in FIDIC 2017, of course, this was rectified. Both employer and contractor claims must follow the same procedure. First, give a notice, then give within 28 days of becoming aware, then give detailed particulars, then the determination or agreement and so on and so forth. Okay, so there is a timeline. Now, there is a timeline. Oops, my animation went wrong there. Okay, there is a timeline with which the claims under the contract are executed, especially FIDIC 1999. What is this timeline? Sorry, my animation is a bit screwed up there, but we'll be able to follow through. So the first thing that happens is there's a delay event. Remember the description we saw in the previous slide? Whenever the contractor considers themselves entitled under this contract for an extension of time or additional payment. So there's an event. I say here delay event, but actually I should say an event or circumstance. It can be a delay, a disruption, or whatever. So whenever a delay event occurs, you have 28 days to give a notice. You have 28 days to give a notice. Now, when you give that notice, the contract goes on to say the engineer may respond requesting further details or requesting the contractor to keep temporary records. One other default that I've observed within the construction industry, especially with you engineers, is that you respond saying, we reject the contractor's notice. You're not in a position under the contract to reject a notice. A notice is simply for the notification of the parties, and we'll see later on why notices are important. You're not in a position to reject the notice. The engineer may respond, and remember, may is an optional endeavor. It's not a compulsory endeavor. So the engineer may respond to the notice, but in any case, may request the contractor to keep contemporary records of the event. Okay? Now, within 42 days of the contractor becoming aware or having or should have become aware of the event giving rise to the claim, the contractor shall submit what is called an interim claim. Why is it called an interim claim? Now, it's called an interim claim because it is assumed that within 42 days, perhaps, the event giving rise to the claim may not have concluded. If the event has concluded, then this interim claim will be considered a final claim. If the event is still ongoing, then the contractor shall proceed to continue giving interim claims at monthly intervals until the end of the effects. Now, after the end of the effects, the contractor has 28 days to give a final claim. Now, this final claim is what now will lead to agreement or determination of the matters in the claim. Within what period? Within 42 days. You can see there's a lot of timelines here, and it's very important as a contracts manager or as an engineer on site to be aware of these timelines. First, you become aware of an event, and you must give notice within 28 days. If you fail to do so, you risk losing your entitlement. Of course, there are many court cases about this, and we shall not venture into that in this session. But essentially, the idea is that if you do not give notice, then you risk losing your entitlement to the matters which you consider yourself entitled to under the claim. Then after the notice, you keep contemporary records. And what does contemporary records mean? It means things which are happening at the same time as the claim is ongoing, or the events causing the claim are ongoing. So perhaps if you are hampered by inclement weather, or you're hampered by lack of access to site, which is the most common, you keep a record of how many staff you have on site, you keep a record of how much equipment you have on site, and you keep a record of rainfall and all other contemporary records during the period of the claim. It is a must you keep them, and you may submit them to the engineer periodically or at the end of the effects. And after the end of the effects, you submit a final claim, and the engineer has 42 days to agree or determine. Now, watch this. There are two things which apply in FIDIC contracts: agreement or determination. So the contractor says, I'm entitled to A, B, C, D under subclause C, D, E, F. The engineer agrees. If the engineer disagrees, then the engineer shall make a determination. And this is what you'll hear in the industry called a fair determination. Okay, we have our first coffee break there, and I'll rush back to Renee so that she can ask her question, and then we'll proceed. Yes, Renee.
Good evening, Engineer Barasa. So I wanted to actually just verify. Okay, my point was, if you go back to clause, okay, between the two, the 20.1 and the 20.5. So in terms of the contractor, it says you shall give, you give notice to the engineer describing the event or circumstances giving rise to the claim. Fine, you are giving a notice. And now for me, describing, maybe that's where I'm a little bit confused, because describing for me is giving details. I'm not sure if I'm correct. Maybe you can then correct me there, because
Yes.
now I'm trying to find the difference
Yes.
between describing and also
Yes.
giving particulars, because I can give you a notice, but I will probably highlight. And also then when I submit the claim, it will have the full details. But when you say give particulars in terms of the employer, my question is, the particulars, is it a full description, or is it also in terms of what is it that I would want to claim from you? Thank you.
Wow, amazing. Renee, that's a very brilliant question. And actually it's very pertinent to understand the intention that the drafters of this contract had when they were stating this. What I believe the drafters of this contract were stating when they were saying this, number one, for the contractor, let's focus on the contractor's part first of all. They say, describe the event or circumstance giving rise to the claim, not the effects, Renee. Not the effects that this event has had on your project. You're just describing the event or circumstance giving rise to the claim. Example, you are working in the city of Johannesburg on a high-rise project, and then there's a workers' strike at the port of Port of Durban, I guess, which affects your shipment of materials to site. You don't know the effect of the worker strike at the Port of Durban, where you're shipping your material through all the way to Joburg. You don't know the effect it will have on your project. But you know that it is an entitlement under a clause of these conditions, worker strike or force majeure, or whatever clause under the conditions that you'll be referencing. You're aware that it is an event that is giving rise to a claim. And within 28 days, you should describe this event. So you should give it in as much detail as possible. Dear Mr. Employer, I've become aware today that there's a worker strike in the Port of Durban. The worker strike, we do not know for how long it will persist, but what we know is that it will hamper our shipment of materials. The following materials are at port awaiting offloading. If the workers continue to strike, we'll be unable to offload these materials. That's the event or circumstance that is giving rise to the claim. You don't know the impact it will have on the project yet, right? But it's valid because you're entitled to it. So you give notice and you describe the event. And you give as much detail describing it as possible. If it's gazette notices, if it's publications of the strike, if it's notices from the workers, and so on and so forth. Because that is simply a notice, and you're notifying in as much detail as possible the employer. You're not stating the effects it will have on your project, which is what will come into your particulars now. When now you're submitting your particulars, you tell the employer, hey, Mr. Employer, do you remember the notice I gave you a couple of months ago, a couple of weeks ago? The strike has now concluded. The workers went on strike for 42 days. During those 42 days, our material was held at port. We were forced to pay demurrage charges at port. We were unable to proceed with the works, finishing works, ABCD. So that is the effect that it will have on your project, which you now describe in your particulars and justify in your particulars. I trust that is clear. So the notice only describes the event or circumstance giving rise to the claim. It does not describe how it has impacted the program or the particulars of your claim. It's only how this event relates to your contract. I trust that is clear. Your second question was notice and particulars. Now, here I think, Stanford, I've noted your hand, will come to you. The second part here, and Ibatha as well. The second part here, I shall be allowing only 3 questions per coffee break so that we finish the material. So keep your comments for the next coffee break after we finish the next 3 guys here. So the 2.5 speaks about notice and particulars. Now, the drafters did not give a timeline. I don't know if it was an oversight or if it was deliberate, but there's no timeline. So, I mean, the employer has all the time to prepare the notice and particulars without being limited to time. So that's the difference here. So you can take your time, prepare your notice and your particulars and give them to the contractor. But I also believe it was assumed in 1999 when they were drafting this, that the employer does not have many claims to make, which is usually the case. You only, perhaps as an employer, you only have claims for delay damages or a few additional costs here and there. And by the time you're getting to the point of delay damages, surely you have all the particulars at hand. The contractor was meant to finish at this time, has not finished at this time. Or if it's to the extension of the defects period, again, you have all the particulars. So perhaps that's why in the previous versions, they limited subclause 2.5 to a very narrow definition without strict time bars as it is in 20.1. By the way, 20.1 is about, I don't have my FIDIC books here, but it's about 3 pages long, if I'm not mistaken. And 2.5 is just a paragraph long. So you can see the difference. But I trust that Renee have fully satisfied your question. Next
Yes,
question
thank you
was
so
from...
much.
Next question, thank you. Next question was from who? Who else had it? Stanford, okay. Then we'll move on to Mr. Abiathar. Stanford, please. Stanford. While he prepares, perhaps Abiathar, you can proceed.
Okay, thank you very much. So based on your explanation of the notice, is it safe to say an early warning is an example of a notice or is a form of a notice? Because from what I know about early warnings, it's basically informing the client or letting the people know that this is the possible delays that's going to occur if, let's say, a material or an item is not received on time. Is that correct?
That is correct, Mr. Abiathar. Now, FIDIC does not use the term early warning. Early warning, you'll find it in other forms of contract, like the JCT, I believe. The JCT uses that term early warning. FIDIC does not use the term early warning. FIDIC 2017 uses the term advance warning, okay? It's always good to restrict yourself to the terms which the contract you're using uses. So yes, it is an early warning, and that's actually the purpose of a notice. It's an early warning to the other party, but FIDIC does not use that part. It uses that term. It uses the term notice. FIDIC 2017 uses the term advanced warning. Early warning, you'll find it in JCT, and I believe, which is the other NEC contracts use the term early warning. Okay.
Thank you very much.
You're welcome. So I trust I've satisfied. We've looked at the timeline. We'll have a next pause in the next few slides for your questions. So all sub-clauses relating to claims in FIDIC are of the format, well, I say all, but not all. There's some which are not. So most sub-clauses relating to claims are of the format: if the contractor suffers delay and or incurs cost, blah, 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 the contractor shall give notice, blah, 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 and shall be entitled, subject, underline the word subject, to subclause 20.12, A, an extension of time, blah, 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 and or payment of any such cost, and it goes on and on. So these are the clauses which in 20.1 are said to be under any clause within these conditions. Any subclause that relates to claim that has this format, there are many others, but any that has this specific format is a subclause under this condition, which you as a contractor, should you encounter that event relating to that subclause, can raise a claim. Now, subclause 20.1 is what in the industry is called a procedural clause, meaning it has steps that you must follow. Remember the timeline in the previous slide? Start with a notice within 28 days. Then after the notice, give detailed particulars within 42 days. Then after the detailed particulars, interim claim, and so on and so forth, and so on and so forth. There's a procedure. Now in FIDIC 2017, the procedure is even more strict because it's more rigid, and they've tried to tighten holds which were experienced in the past 15 years since, was it 15? Yes, since FIDIC 1999. Again, here I quote it again just to refresh your memory, but also just wanted to highlight that part. Under any clause of these conditions. What does it mean under any clause of these conditions? There are certain clauses which give the contractor entitlement to make a claim. What are these clauses? For example, clause 1.9 speaks of delayed drawings or instructions. Clause 2.1, if the contractor is denied or has late access or possession of site. 4.7, errors in setting out information. Now you can already see, if you're an engineer and you'll be working for consultants, two of these relate directly to what you'll be doing on site. If you delay to give drawings or instruction, the contractor will claim. If there's errors in setting out information, the contractor will claim. Now, if there's adverse physical conditions, the contractor will make a claim. If there's fossils which are discovered on site, if there's any delays in the testing, and so on and so forth. Delays caused by authorities. The government has decided the President of the United States is visiting, so all roads in the city of Maputo are shut. These are delays caused by authorities. The contractor can claim. The engineer's instruction to suspend work under clause 8.9, where the engineer instructs the contractor for one reason or another to suspend work, can cause the contractor to make a claim. If employer interferes with tests on completion, I don't know how common this is. I've actually not encountered it in my practice, but I can imagine how it can happen. The contractor can claim. If under 16.4, if the contractor terminates, there's certain grounds under which they can make a claim. Employer's risks and force majeure, the most common and wrongly applied clause in contract management. So these are the contractual bases or the clauses which are referred in this subclause under any clause addition or otherwise in connection. And that is why you see the other is in connection, is why I said not all sub-clauses have this syntax. Not all of them share this syntax of if the contractor suffers and so on and so forth. So it's good as a contract manager to go through your contract and note what are the causes of delay giving an entitlement to extension of time under a subclause of this condition. I could have missed some here. These are the ones I have noted. I could have missed some, but these are the ones I have noted. Now, we've spoken about notice, and Renee has asked a very good question about notices. You should give a notice first. Why should you give a notice? A notice is what is called, okay, my animations are reversed. I don't know why. A notice is what is called a condition precedent. A condition precedent means something that must occur before the claim is validated. Now, as I said in the beginning, there are many case law precedents about conditions precedent, and depending on the system of law you come from, and these have an impact on future judgments. So it's always good to always restrict yourself to what the contract says and give the notice. Now, why is a notice important? Because everyone involved becomes aware that there's an event or circumstance, and this was Ibatha's question actually. It's an early warning. Everyone becomes aware that there's an event or circumstance that if you don't resolve it, will have extra time and cost implications. Then you can keep proper records and agree to avoid future disputes. Okay, there's a strike in the port of Durban where our material is coming in from. So let's keep records. Let's keep the number of people on site so that we don't argue in future about you didn't have this number of people on site and so on. Thirdly, you can have alternative measures to mitigate the effects. And this is why notices are important. And sometimes as employers, we look at notices as an aggression from the contractor. But no, a notice should be a means of alerting you that this event is coming. And perhaps you can do mitigation measures. Perhaps you can do a change in design if the notice requires something to do with design. Perhaps you can realign the route, or we can reschedule the program, start a different section because there's water logging in this particular section of the road. We can reduce the scope, etc., etc. The matter may be resolved at an early date. And this actually blends into Abiathar's brilliant question, which was, is it an advance warning? Yes, a notice is important as an advance warning. But more so, it's important because if you do not give a notice, as per FIDIC contracts, you may risk losing your entitlement to claim. Okay? We've looked at clause 2.5 and we've said that's what it says, but it goes on to say down here at the bottom that a notice is not required for payments due under water, gas, and so on and so forth. So there are exemptions to giving a notice for the employer under FIDIC 1999. Oops, sorry. We've looked at the elements. We've looked at the notice first, reason for giving a notice. We've looked at the definition of a claim. And now we want to look at the contents of a claim. What makes a solid claim or a reasonable claim? Due to time restrictions, and of course, perhaps that's content which you may need to pay for first, I'll not delve into the depths of it. But just on the surface, what elements must there be in a claim? In the claim industry, somebody called Robert Knowles, I believe, he was a very astute contracts manager and construction lawyer, came up with what he called the CEES acronym: cause, effect, entitlement, substantiation. Your claim must demonstrate those four things. By the way, a claim need not be 200 pages of a claim if you're a contractor preparing a claim, or if you're an employer preparing a claim. It can be a page. As long as you demonstrate the cause, which you needed to demonstrate in your notice anyway, you demonstrate its effect on your program or on your finances, you demonstrate your entitlement under the contract, and you substantiate How do you substantiate? By giving the contemporary records which you are keeping during the period of notice. How do you demonstrate your entitlement? Simple, by referring to the clause under which you are justified. The effect should be demonstrated on your program, which means you must be good at program. Remember, in our second seminar, we spoke about having a good program or keeping good records. And the cause, of course, is the issue giving rise to the claim. Now, I just want to open up the floor to four people. I want the first person to imagine a cause for me. Just imagine one cause of a claim or a reason or a circumstance giving rise and state it to me. Then we move to the second person to give an effect, then entitlement, then substantiation. Let's go.
I'll suggest.
Okay, let's do hands. Let's do hands so that let's do hands so that we have some order, please. Abiathor.
Yeah, so delays in issuing drawings to a contractor.
Okay, so delay in issuing drawings, that's a cause. Okay. Let's have somebody else give us an effect of that. How that affect your program? How would you describe it in your claim?
Delayed the execution of that particular work.
Okay, so give me an hypothetical particular work. So you've said there's a delay in. So hypothetically, which work would be delayed by a drawing?
So let's say flash float foundation.
Fast flow. You said raft foundation. Well, let me raft foundation. Okay. So the delay in drawing. So how does this work? Okay. Oops. Okay, let's go on. So there was a delay in issuing of a drawing, which has resulted in the delay of execution of a raft foundation. Now, is the delay in execution of the raft foundation an effect giving you entitlement to extension of time, Stanford? Or can you recover this time later on? Yes, Stanford? Yes, Stanford? Okay. Anybody else? Stanford seems to be having an issue with his microphone. Anybody else? I want to know, you've been delayed in receiving this drawing and you've not started the raft foundation, but you have 3 years to complete this project. Surely you can recover. Okay. What I want to hear, yes, Philip. Yes, Philip.
Yeah, thanks, engineer. Yeah, it would depend with the amount of days or months delayed. Because I understand if there are more, I think you may not be able to recover. If it's maybe 1 week, I think maybe that's something we can work with. But if we are talking of months, then maybe it may be a challenge.
Okay. So let's refine our claim based on what Philip has said. So the delay in the drawing, and by the way, when you're giving this drawing in a normal claim, you'll say these drawings were referenced, let's say drawing 001 for the foundation. Okay. And the delay in this drawing has resulted in the delay in start of execution of raft foundation, resulting in X number of delay as per our program. Because remember, the contract is governed by a program, okay? Now, you've carried out a delay analysis. This is the response I was waiting to hear from you. And it affects the critical path. So this word here, critical path, is a term that is used in the construction industry to mean the longest, and perhaps those of you who have a background in project management, the longest path to completion. Meaning there's no float, meaning there's no room for delay within that path. And you must demonstrate this effect in your claim. Then you move to the third part, entitlement. Quickly, anybody who can tell me what your claim must demonstrate as an entitlement? Yes, Renee.
Okay. Basically, I think this is where the contractor actually gives a breakdown of the costs in terms of how much has the contractor suffered, or probably the estimate of how much was the cost of the delay, based on the program of the work that should have been done according to the program that was on the critical path. Because now that is where the contractor would have been on site, but he's not making money. And so therefore they're entitled because they would have done this work, which is valued so much. I'm not sure, but that's what I think.
What you've just described, Renee, you've jumped the gun. That is what you're calling substantiation.
Ah, okay.
Yes, so the documentary evidence of what you've actually suffered, you must substantiate, you must justify what you've actually suffered, either as per your program or as per your bank account. As per your program or as per your bank account. So that is what is called substantiation. You must justify and demonstrate your loss. Yes, Ojambo?
I think here in
Oh, your audio is not so clear. Please take it again.
Okay, you must demonstrate clearly how the critical path is being interfered with in terms of critical activities and near critical activities, whereby if there is a shift in the critical path, this has to come out through whatever method of delay analysis you're using, either if it is prospective or retrospective.
I would think that comes into effect, Mr. Ojambo. That comes into effect. That is the effect of the cause. Yes, I see two other hands. Let me see who else. How come I can't see? I just see who's raising their hand here.
Yeah, Abiata here. So I think entitlement will be an extension of time or maybe cost entitlement to extra funds, something like that.
Yes, Avoyele. There's something you're missing, guys. There's something you're missing. Yes, Ojambo, you're back. Who else has their hand up? I'm seeing Kevin. Yes, Kevin.
I think you also quote from the contractual implication of the claim. You can quote the clause that is
exactly.
Yes.
The clause under the contract is what gives you your entitlement. Guys, remember, let's go back. I need to go back here. Oh, it's created a mess on my... If the contractor considers himself entitled under any clause of these conditions. So you'll have to refer to any of these clauses under these conditions, which gives you the entitlement. Okay? Simple as that. It's not complicated. you have to refer to the clause which gives you the entitlement. Okay, guys? Now I need to clear this screen. How did I get these things here? Okay. Yes, Motsamai.
Yeah, I have a question, and it's related to this question that you are just addressing now. But I just want to know that if we have maybe a delay in a near critical activity, let's say in a project we have about 3 or 4 float paths, and then in the later stage, that particular path then becomes critical. Because I want to understand if I'm entitled to claim under any activities which are not on the critical path, and also on the activities which are on the near critical, which will maybe later become critical. Thank you.
Yeah, thanks. I understand your question perfectly, and it's actually a very pertinent question. And you'll go online and you'll find so many cases which people have argued in court for and against the answer to that question. You're only entitled to a delay, and this is my position. You're only entitled to a delay if it actually causes a delay to completion. Now, some people argue that, look, I'm entitled to an extension of time, even if it does not cause a delay to the time to completion, because I had planned to do this work at this time and I've delayed. So your claim is how you present your claim, and perhaps when if we are going deep into the cause and effect, you demonstrate clearly that there are sometimes issues which do not lie on the critical path, but still entitle you to an extension of time. Sometimes, not always, but it's how you argue your claim. And presentation of a claim is all about the narrative that you prepare and the substantiation that you prepare. So if you have a solid baseline program, you can demonstrate against the baseline program that even though this activity was not on the critical path, it still caused a delay, which led to a compounding effect on subsequent activities, which will prospectively lead to a delay in completion, or retrospectively led to a delay in the completion. But an extension of time is only awarded if there's a delay to the completion, to the time of completion. So disruptions may happen in there, but if they do not lead, and if you do not demonstrate it as a contractor or as a contract manager for the contractor, then you lose your entitlement, because you must demonstrate that it led to a delay in completion. So yes, it's very pertinent, the question you've asked, and it can be argued both ways. So here, let's proceed. We'll have another coffee break soon. We just have a couple of slides left, and I'm hoping in the next 15 minutes we'll be done. So the essentials of a claim. I was demonstrating here. These are now my other notes. Subclause 2.1, for example, restricted access. The example we gave in the session was delayed drawings. And then we say it has delay to planned activities, and you must demonstrate which planned activities. What's your entitlement? Subclause 20.1 entitles me to extension of time and cost, and subclause 2.1 also subject to subclause 20.1. And substantiation is reference to project records. So these are the essentials which must be in your claim. It can be 100 pages, it can be 1 page, but you must have all these things in your claim. We finished the first part, which was claims. We're now moving to the second part, which is disputes and arbitration. We start off with the definition of disputes. A dispute is a disagreement on a point of law or fact, or a conflict of legal views or interests between parties. You have the guy there on the left, he's seeing a 6, and the guy on the right is seeing a 9, and they're all looking at the same thing. And they're disputing about it. Of course, in construction, you'll all be reading the same contract. The engineer is reading the same contract, the employer is reading the same contract, so is the contractor, but one is seeing a 6 and another one is seeing a 9. And sometimes somebody is fundamentally wrong and they're seeing a G, or a B. But mostly it's just a disagreement on the interpretation. Hardly ever is it a disagreement on facts. And what are the effects of disputes? Of course, spoiled relations. There's tensions between stakeholders, and you can harm long-term partnerships and collaboration. Disputes are costly. Disputes damage the reputation of parties involved and affect future businesses. And of course, there's reputation risk. Disputes can lead to high expenses from legal fees, delays, and of course, no, that's the other way around. My slides have twisted. So, of course, the reputation risk is that one, and the cost is the one on the left. Please interchange those. So basically, those are some of the effects that are presented. Those are some of the effects that are presented by disputes, or the end result of disputes. And of course, you want to avoid that if you're managing a contract and you want to manage the contract properly. You want to avoid ending up in a situation where you incur cost or spoil your reputation, or even spoil relations with the other party. Okay. So, okay, that picture is just there for dramatic effect. But basically, these two guys are having a dispute, and there's somebody in the middle to come and help them sort it out. So a dispute can be any legal, commercial, or technical disagreement concerning the contract, e.g., a determination made or not made by the engineer. You saw that in the video that started us off tonight. Any certificate or instruction, any remeasurement or valuation. And you can see engineers, again, here you come in, because the engineer is the one preparing the measurements and the valuation. The engineer is the one doing the certification or instructions, and the engineer is making the determinations. So you're central to disputes in the construction industry. So you should be aware of how a contract operates to minimize disputes, okay? In general, the sources of disputes, you saw this in the video that kicked us off. You have cost overruns, scope changes, payment disputes, delays, non-performance issues, design and quality errors. And here again, as engineers, you come in. So these are just lists, and I think this was covered in the beginning video. I can't go into detail a lot, but those are just some of them: changes in scope, ambiguity in contract specifications, late payments, disagreements on measurements, untimely variations, project delay and disruptions. These are all causes of okay. Before we go to our next coffee break, I want to look at how, now that we've seen disputes and we've defined disputes as a disagreement in law or fact, and we've seen the causes of disputes, that disputes are caused by different interpretation of a contract and so on and so forth. How do you resolve disputes? Because you don't want it to end in a fist fight, like the two guys you saw there in boxer shorts. There have to be other ways of resolving disputes other than that. Okay? There have to be other ways of resolving disputes. And in FIDIC, how are disputes resolved? A long time ago, the procedure for handling claims involved the engineer making what used to be called a fair and impartial determination. I learned with dismay that the Kenya National Highways Authority still uses the FIDIC contract from 1984, 1957. It's a very, very old contract, but they still use it as their governing contract for all their projects, even in 2025, which is unfortunate. But long ago, the procedure there was that the engineer used to make a fair and impartial determination. And this decision was binding. So you have, in either case, if either party was dissatisfied with that decision, they could take the matter to arbitration as the next step. But now a small problem arises. You have the employer on one side, and you have the contractor on the other side. And you have disputes arising. And you have this guy called the engineer, and he's expected to act with impartiality or fairness. But he's an agent of, and is hired by, and paid by the employer. How will he be impartial? You cannot be the referee and you're only sponsored by one side. So that's the 1984 version of 87 version of FIDIC. 84. In 1999, FIDIC decided, okay, let's let's tweak this a little bit. So now what they introduced something called the dispute board. At times you'll hear it being called the DB, other times the DAB, meaning Dispute Adjudication Board. We won't go into the details, sadly, in the interest of time, but basically, it's an element of FIDIC contracts which was introduced to act with impartiality. So you have the same scenario. You have the engineer, you have the employer, and you have the contractor. The engineer is an agent of and acts for the employer and is still expected to make determinations with impartiality. But in case the parties are dissatisfied with the determination of the engineer, they can then refer it to the dispute board. So the dispute board was introduced in FIDIC 1999. Note, in FIDIC 2017, they call it the DAAB, Dispute Avoidance and Adjudication Board. So there's an element of avoidance which has been introduced, but we'll not get into that, unfortunately, due to the interest of time. Then we have arbitration. So look, okay, we'll come back to that. So arbitration is given in subclause 20.6, and usually arbitration is entered, and I believe there are some arbitrators. I've seen some names on this conference. Some arbitrators are here. Is entered only if one party is dissatisfied with the DAB decision. Most arbitrators will actually ask you if you've satisfied all the dispute resolution mechanisms before referring the matter to them. So make sure as a contract manager, you exhaust all the previous methods before referring the matter to arbitration. You cannot jump the gun. When you're dissatisfied with a DAB decision or dispute adjudication board decision, you give a notice of dissatisfaction within a given time. And if there's no amicable settlement, within 56 days, arbitration commences. Now, FIDIC has standard rules for arbitration. It should be done in the ICC. There should be 3 arbitrators or 1. And in the language of communication of the contract, you can amend this in your particular conditions. Remember the first seminar we spoke about particular conditions. You can always amend. You can, instead of saying International Chamber of Commerce, you can say the Nairobi Arbitration Center or the Uganda Center for Arbitration, or the, what's it called in Cape Town? I don't know, the Dubai International Arbitration Center, Singapore International Arbitration Center, and so on and so forth. So you can choose the rules, London, what's it called in London? LIAC, and so on and so forth. You can choose. You can also choose the language of communication. If you're in Tanzania, you can choose Kiswahili, or in South Africa, you can choose Zulu, in the particular conditions. And then also you specify the place. Now, perhaps the lawyers here will tell us what's the difference between a seat and a place of arbitration. So these are the dispute resolution procedures under FIDIC contracts, and I think we're close to the final slide. Number 1, we say that a claim event occurs. Oops, my animation is wrong. Oh la la. Okay. My animation. Anyway, let me use the highlighter. This was meant to be animated, but things went awry. So a claim event occurs. Contractor gives notice, or the other party, the employer, gives notice, followed by claim particulars, which are details of the claim. Remember the CEES, what was C? Your CES, your entitlement, your
cause, effect, entitlement, and
substantiation. Thank you. Thank you. My memory fails me. Cause, effect, entitlement, and substantiation come in here. Now, FIDIC says the engineer shall negotiate with, this is a part which many engineers miss. I don't know why, yeah? And it's actually written there in the contract. If you look at subclause 20.1 in FIDIC 1999, it says the engineer shall negotiate with the parties in an attempt to reach agreement. This is the first step. Most engineers skip this, and I don't know why. And if you reach agreement, then you settle the claim. If you do not reach agreement, the engineer is meant to make a fair determination. If the parties agree, then you reach settlement. If the parties disagree, then you refer, or rather you can discuss with the dispute board. You refer the matter to the dispute board. This is what is called an informal opinion. The dispute board can discuss and give you guidance under what is called an informal opinion. Then you settle the matter. If you disagree with the informal opinion, then it becomes a dispute, capital D. You move here. You now refer it to the dispute board as a formal matter. Difference between here and here. Here it's informal and the decision is not binding. You're not bound by it. an informal decision. But a formal decision, now the dispute board makes it and you're bound by it. Now, there's many court cases as to whether the dispute board decision is final and binding, and you'll find judgments on both sides of the road. However, in most cases, the dispute board decision is binding, which means you must execute it, argue later, right? So if you agree with the DB decision, you've settled your claim. If you're dissatisfied, you have yet another chance to negotiate and settle. Within 56 days, if you don't negotiate and settle, then you can commence arbitration, and arbitration is often final and settled in a court of law, using the governing law of your contract. So you can see that this FIDIC has afforded us many steps to resolve disputes. And just by looking at this flowchart, I can guarantee you that all these boxes are different career paths that you may take. You can be an arbitrator, you can be a DB member, you can be a negotiator or a settler or a mediator, you can be a dispute board member, you can be an engineer as you are, you can be a claims expert, you can be a planner, and so on and so forth. So all these boxes relate to have spawned careers of their own over the years and have become very interesting careers. But it need not be complicated. I mean, it's fairly simple, but of course, disputes has become a large industry in the construction industry. And many people are taking advantage of it to gain their daily bread. Ladies and gentlemen, I have spoken enough, and that brings us to the end of our session today. I hope you've learned something. We can have our final tea break before I say thank you and good night, in case you have any questions. Yes, Mr. Philippe. Mr. Philippe Hope. And who else? Let me stop sharing so that I can see the hands are up. Can see. Okay, let's start with Philippe, then we'll move to Ojambo. Let me stop sharing so that I can see whose hands are up.
Yeah, thank you. Nice one, engineer. Thank you very much. Very insightful. Just have one question. How is the dispute board formed? And what is its position?
Okay, good question. Okay, let me check all questions. So that's Philip. Where's my pen? Philip is asking, how is dispute board formed? Okay, I'll answer that. Next question from who? Oh, Mr. Ojambo.
My question is what happens if the project gets delayed even after an extension of time?
Okay. Okay. So that's very common actually, Dennis, very common. So yes, Mr. Tsoyo.
Yes, thank you for such an informative session. It really does help. I have just one last question to say. In a project where there's a PMO, and then within the PMO there's a PM, but then within the structures as well, there are, say, administrative structures within the PMO itself. What happens in a case where there's a claim from a contractor? Does the claim have to be processed to? Okay, so between the PMO and the contractor, there's also the consultants or the engineers. So now, let's say there's a claim from the contractor. Does the claim get worked by the engineer and then resolves it, or does the engineer give a certain what would I say? This is like, does the PMO still own the claim, management in a way, or does it only get involved in a case where there's now a dispute? I don't know if you
Got
can
you.
you
Let's
get
go.
what I mean.
Yeah, I've got you. I got you. I got you. Let's go to Renee, then I'll answer those 4 questions.
Thanks, engineer. I think I just wanted to ask in terms of, let's say, a scenario where the contractor, okay, let me say there's a delay from the employer partly, or from the employer and the consultants, and that leads to, and let me say, I don't want to say that leads, because everyone will have to dispute will have to, defend their position, but then it gets to a point where the contractor does not do work, even though there's work that needs to be done, that can be done in terms of the program. But now it gets to a point where the contractor then leaves site because they feel they do not have enough work to actually be on site, and they're not making enough money to keep them on site. Is it looking good in terms of a claim? Thanks.
Okay. So yeah, that's pretty common as well. So number 1 was process of formation of the dispute board. Now, dispute boards are formed in 2 ways. The first way is what you have an ad hoc dispute board. An ad hoc dispute board means you call them on a case-by-case basis. Should a dispute arise, you call the dispute board. And the second way is what is called a standing dispute board. So right off the bat, from the beginning of the project, you have a dispute board. How is this board formed? It's either 1 or 3 people. Why 1 or 3? Odd numbers. Odd numbers will call it down the middle. So 1 person will make a decision down the middle, and 3 people will make a decision down the middle. If it's 3 people, how do you appoint them? If it's 3 people, the employer comes with 1 person, the contractor comes with the other person, and those 2 people then appoint a 3rd person who will be the chair. So obviously the 3-member DB is easier to appoint. A 1-member DB, you have to agree on whom to appoint. So if I come with my guy and Philip Hope comes with his guy, I'll say, no, my guy should be the DB. And Philip will say, no, my guy. And of course, we'll never reach an agreement. So please, when you're drafting these contracts, ensure you put 3-member DBs. It's easier to appoint. Once those 2 appoint the 3rd person, the 3rd person becomes the chair, and they make decisions and call it down the middle. In case you're unable to, and if you look at clause 20.5, it describes, in case you're unable to reach agreement, then you can write to FIDIC to assist you to appoint a dispute board, essentially. Mr. Ojambo asked, what happens if there's a delay within a delay? That happens more than you can imagine, and it leads to more disputes than you can imagine. If there's a delay within a delay, same process. Contractor writes a claim. The claim is determined or agreed. If it's disagreed, then you can go through the dispute procedures. But it's the same process, essentially, but it happens more often than not. And usually, by that time, everybody is tired, but the same process. Write a claim and have the engineer agree or disagree with it. If they disagree, go through the dispute resolution processes as per the chart that we spoke. Now, Mr. Motsamai asked, what happens when there's a PMO? Now, these are structures which we in the industry formulate ourselves. If you look at the FIDIC contract, there's no room for PMO. There's room for 2 people, the engineer and the contractor. The employer and the contractor. And the employer appoints somebody called the engineer, who is not a party to the contract, but acts on behalf of the employer. So there's only 3 people. And we spoke about this in the first seminar. Engineer, contractor, employer. Anybody else is outside the food chain. They have no part whatsoever. Renee asked about abandoning of site. Now, depending on what you want to do, if a contractor abandons a site under subclause 15.1, I think paragraph G, or is it G or C, you're entitled to terminate the contract. Now, termination is usually a very drastic step, so usually manage the situation if the contractor abandons the site. And if the contractor is not carrying out work, then you as an employer have the latitude under subclause 2.5 to make your own claim for delay damages or other claims under the contract. So there's room to make a claim if you do not want to take the drastic step of termination. But usually the solution for suspension or abandonment of site is termination. But that happens a lot. Abandonment of site because there's no money or there's little we can do on site. It happens a lot. But you should keep contemporary records and submit your particulars and always have your records on point. In the comment section, I can see in the chat, there's guys who made some comments. EOT, that's Marilyn, EOT and cost plus 4. Oh, this was relating to the questions we were asking earlier about entitlement. State which part of the clause? Yes. Quoting events? Yes, exactly. Is it possible to share the presentation? The good guys at Roads Hub will tell you. Is there any recording of previous sessions? The good guys at Roads Hub will tell you. Can we please get the slides? Hey, you guys want my slides for free? Hey, you will have to pay. No, I'm just kidding. The Roads Hub guys will give you the slides. Thank you, engineer, for your clarity. Thank you. Much obliged. Much obliged. Who pays the DB? Ah, good question. Yes, I didn't cover this, did I? Yes, this is a very good question by Mr. Daniel Mulonzia. Who pays the DB? Now, remember, FIDIC introduced the dispute board as historically, let me recap the history. Historically, it was the engineer who was determining disputes, but the engineer is appointed by the employer. And when the engineer is appointed by the employer and paid by the employer, there's that question of impartiality. Is this guy really impartial? Is he fair? Most of us here are Africans, and of course, we know this when we approach election seasons. The guys who are appointing the electoral bodies are the same guys who are paying the electoral body. Do you expect them to be fair? It was that kind of thing, as a side note. So FIDIC came up with a dispute board, and I've just explained that the dispute board is appointed one half by the employer, the other half by the contractor, and a third party by those two who have been employed. Who pays them? The fee is shared 50-50. So the contractor, and it's not in case of a dispute. Dispute boards are standing throughout. So ordinarily you pay them monthly, you pay them a monthly fee. And those of you who will want to get into dispute board membership as a career, it's very fruitful because you're paid monthly, a monthly retainer, not only in case of a dispute. When a dispute arises, and this monthly retainer is split 50-50 between the employer and the contractor. So if the dispute board member's fee is $2,000, the employer will pay $1,000 and the contractor will pay the other $1,000. And that is just so that there's a balance of fairness, that it's not only one person handling the payment and the appointment. And this one person, and these two people are sharing the cost. And so the cost, the cost is shared, and so there's the aspect of fairness. And of course, in FIDIC contracts, in your BOQ, when you're pricing for your BOQ, there's mechanisms on how to split the DB costs. So essentially, the contractor will be paid for paying the employer's half, that kind of thing. There's a mechanism that you usually put in the FIDIC contract. Stanford asked, on delay notice, do you claim through progress reports or other means? Again, Stanford, a notice is information. You're not claiming through your notice. After the notice is when you'll give your detailed particulars. In your detailed particulars is when you'll do your CEES. Okay? When you do your CES, under your substantiation, the S part is where you'll put your progress report or any other means. I'm new. This is my first session. How do I get on board going forward? Mr. Philip, this was the third session I am holding. The guys at Road Hub will have other sessions in future. Maybe you can get in touch with them. But this is the third and last session, unfortunately, that I am holding. Ms. Veronica Abere says, let's say EOT was granted to date 10th as a completion date, but the contractor without another. Yes, levy delay damages, those 5 days, they're delayed. Levy delay damages for those 5 days. Roads Hub has said FIDIC recordings. They have answered your question. So it's on YouTube. You can click on those links and you'll see part 1 and part 2. And I'm sure they'll upload this part 3 right after. I hope I'm looking good enough to appear on YouTube. I think the question refers to concurrency of the delay. what was that about? I don't know. Could you please make a comment? Yes, Mark. There's one going down tomorrow for Q2. Yes, Mark, you've asked this question even in the first seminar. Okay, Mark, I'll address that after I finish all comments. How are disputes between the main contractor and subcontractors resolved? You have your contract, right? So the contract I've been speaking about is between the employer and the contractor. The contractor and subcontractor has their own contract, which governs how the disputes are resolved. But ordinarily, if you're using the FIDIC subcontract form, more or less the same procedure. You have a contractor's representative. You don't have an engineer in that case mostly, but you have a contractor's representative, and you have perhaps a dispute board and so on and so forth. So the contract between the contractor and the subcontractor will govern how disputes are resolved. What we've been speaking about is for the main contract. I trust that is all. Did I see a hand from Rene?
No, oh no, it's fine. I think I was also interested in terms of the disputes between the contractor, the main contractor, and the subcontractors, and also if maybe their contract is also. Can you hear me? Okay. Yes, engineer. So I was wondering if their contract also would follow, even though they've got their own contract, which is the main contractor and the subs. Do they follow?
Yeah, essentially they have their own contract, and they have their own contract, and it'll be governed by that contract. They have no part whatsoever in the main contract. They have no part whatsoever in the main contract.
Follow the FIDIC procedures of how it was going to be done, because it's our project. Okay, I understand.
Okay, so lastly, before we break, just quickly, for the benefit of those of you who want to take the FIDIC contract manager program, so basically, it's a practical-based exam. It's not theory. You can't study for it. They ask questions based on your practice, and perhaps if you attend such seminars where you interact and share other people's experiences, plus your own experience, is what you'll be asked about. There are many things that these guys ask, and they're all on their website. If you go on the website, they've put a curriculum. They'll ask exactly what is on the curriculum. So they'll ask you to I don't know if I have it here. One moment, Mark. I have it here. I have a small presentation, just one page. Then we close. No, that's confidential. Okay, so basically, sorry, I almost opened something confidential. Basically, Mark, just read the FIDIC Red Book, read the FIDIC Yellow Book, read the FIDIC Silver Book, then download the golden principles from their site, from the FIDIC site is what I mean, their site, and go through this and internalize. But the rest of it really is, I found it. The rest of it really is your practice. Now, I did that exam a couple of years back. I know things have changed a bit. But this is how it was. There's no training provided. You can go online and read for yourself, but mostly it's a practical-based exam. It's 250 minutes. That's about 4 hours. And then there's 100 multiple choice questions. You need to have practical knowledge of FIDIC books. They don't test you on memory or general knowledge because you have the books with you. You'll carry your copies of FIDIC with you to the exam room. So you'll have it. And then they'll not ask you which clause says X, Y, and Z. No, they won't ask you what does subclause 20 say. No. This is an example of questions I remember from back when I did it in 2019. Maybe things have changed now. So they'll ask you which of the following is not correct. Then 2 possible answers. Then you go through this, and it says the contractor has no obligation to deliver the performance security. The contractor must deliver the and so on and so forth. So you must look at which one is not correct, and you tick and you tick and you move on to the next question. I noticed when I was doing it, they were concentrating more on 2017 FIDIC, so please refresh your knowledge on those. And as I've said, it's an open book exam, and you should have a copy of the red, yellow, and silver book and bring them to exam room. You can also print out the golden principles. They're available on that website, fidic.org, fidic.org, and memorize them. There are only 5 golden principles, so memorize those ones. But they'll ask you, you'll have them anyway, so no need to memorize, but just know what they talk about. And you'll have at least 1 mark, so you can't really fail. Or at least you'll fail, but you'll have something. You'll need to go through 1999 books as well. I remember I saw only 1 or 2 questions from those, but most are from the red and yellow book. So basically, 2017 books, 1999 books, know them cover to cover, and you're good to go. The questions ask different kinds of questions, which FIDIC book is appropriate. We covered that in this seminar, so you shouldn't fail that mark. We covered it in the first seminar. So you'll be given a certain context and asked which FIDIC book is going to be used. I think we did that in the first seminar. Things about performance insurance, we didn't cover that. Termination procedure, etc., look at that. Payment processes, we did this in seminar number 2. Periods, the 28 days, the 42 days, all those things. We've covered claims notices, periods of notices, the 28 days, the 42 days, all those things, both in 1999 and 2017. We've done adjudication boards and setup procedure, which gentleman has just asked right now, and everything basically cover to cover. So if you're confident enough that you've used a FIDIC book in practice, you are good to go. Thank you very much, guys. I think I've taken enough of your time tonight, and I'm pleased. Thank you very much, James, for inviting me. I hand it to you.
All right. Thank you very much, Engineer Barasa Ongeti, for being our very knowledgeable, kind, interesting, and of course, very educative facilitator for the last 3 webinars. I really, with the entire community, we are very grateful for you, for your willingness to share the knowledge that you have accumulated for years freely to all of us. So thank you very much. We honor you, and thank you. I know that today we've really learned a lot. I do not intend to spend any much more of your time. I am just going to make 1 or 2 announcements, which I consider probably also valuable. Number 1 is Engineer Barasa will be hosting FIDIC training classes. Is in the process of putting everything in place. So once this is announced, I'm going to communicate it to you so that now you can have an in-depth learning on the same. Secondly, we have recordings for all the 3 sessions we have had on FIDIC, contract administration. And I've already shared 2 recordings in the chat box. That is in case you would want to revisit them. I think you should. I will just resend them 1 more time in case you missed it. This recording also shall be shared tomorrow morning, probably around 10 a.m. GMT plus 3 hours, and you will find it there. Lastly, and not the least, we have another webinar on sanitary sewer design for people who are interested in designing utilities in the water sector. And so if you're interested in that, I'm going to send the notification tomorrow. Over and above that, we have the sanitary and sewer design training. This is where you design sanitary sewer systems using Civil 3D, and it is right on our website, RONSAB, and you can be able to purchase it right there. We have 50% booking going for already. So the sessions are going to start on June 30th. That is next week. We also have the Civil 3D training that is going to commence on July 7th, 2025. So the enrollment is also happening. This is very good for people focused on highway design, urban development. It targets beginner to intermediate level. So it's starting on July 7th. So please also, if you would want to enroll into this program, you can be able to go to the website. I'm going to send the link right now in the chat box, and you can look at it at your convenience. Oh, sorry, I think I didn't copy it. Let me do this. Let me just do this and send it to you right now. So for example, that's for Civil 3D. You can go to the website, www.roadsub.org, and then go to courses and you find it. Over and above that, we're having Revit for structural design training. And this one is going also to start on July 14th. We are also bringing on pavement design. This is technically for intermediate. It's going to be 2 modules for beginners, intermediate, actually 3: beginners, intermediate, and then expert. It's going to cover both flexible pavement and rigid pavement. We are rolling out flexible pavement first, and then we'll have rigid pavement come August 2025. So those are basically the news that I have for you. So stay tuned. I'm going to send the recording and also this very information to your emails and also to our social media pages. So please, if you haven't followed us, let's go and check and write RONSAB. And then you're going to find it there. And this is right here. We have 8,000 followers who would want to grow and reach more engineers worldwide. You can also follow Engineer Barasa Ongeti. So this is Barasa Ongeti. It's the same picture. It doesn't have many of them. When we meet next, I must take a picture of him. This one has been here for ages. I knew him 3 years ago. It was the same thing. It doesn't also grow older. So Barasa Ongeti, in case you have any special inquiry, you would want him to help you out in any matters, contract administration, please reach out to him. That is his name, Barasa Ongeti, and he's very kind and going to help you. So thank you very much for your time and attention. And again, to our Kenyan brothers and sisters, we again empathize and mourn with those who have lost their brothers and sisters in the struggle for the liberation of our country from the kind of leadership that we have. And as we grow, I hope that also you, the young brains that are in this community, are going to take over leadership. If you don't, I will. I'm preparing myself, and we will have the change that we desire. So thank you very much. I'm wishing all a fantastic night. Again, to our very own Barasa Ongeti. Thank you very much. I'm looking forward also to meeting you very soon. And we have our usual conversations. Santeni sana. I'm wishing you all a fantastic night and a productive week, and wish you all the best in your professional endeavors. Thank you very much. Everything shall be provided. Asante. Have a good night, everyone. Thank you.